Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, within and before the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning, Ms. Fallon.
SJC-10429, Commonwealth versus Fluellen.
Good morning, Mr. Hill.
Good morning, members of the court. My name is Nadell Hill, representing the defendant, Mr. Jimmy Lee Fluellen. Before getting to the defendant's joint venture issue, he would like to first address the confrontation clause issue that he raised in the supplemental memorandum of law. The initial point is the Commonwealth has argued that this issue is not properly before you because the defendant did not raise it until the supplemental memorandum of law. But the defendant would point out that based on the information publicly available on your website, in the Connolly case, which has the same issue decided by this court in September, the defendant did not raise the issue until the supplemental memorandum of law that he filed on the 14th of July, 2009. The defendant in the present case filed a supplemental memorandum on the exact same date, simply asking for the same treatment, given the same standard that you treated with defendant Connolly. Now, in the Connolly case, you didn't really settle the question of whether the clairvoyance exception will apply to cases such as the Connolly case and the present case. Recently, the appeals court in the case Commonwealth versus Vasquez decided, I believe, the 16th of October, held that the majority held the clairvoyance does not apply in these types of cases. The defendant responds that regardless of what you call it, the question to be decided is whether the defendant will be excused for not objecting to certificates of analysis coming into evidence. If you hold that the defendant is not excused, you will in effect be holding that the defendant will be penalized because he relied upon what this court said in the Verdi case. In the Verdi case, you stated in no uncertain terms that certificates of analysis do not violate the confrontation clause.
The trial in this case was in June 2007. Now, that was that before the United States Supreme Court granted cert?
Yes, it was, Your Honor.
It was. So.
It was. Yes, Your Honor.
Yeah.
But the court had granted cert at the time you filed at least the gray brief, correct? Or maybe,
that is correct, Your Honor.
Was it the blue brief or the gray brief? I understand your point about Connolly. Leaving Connolly aside,
Okay.
Was it the blue brief or the gray brief?
I believe the blue brief
I saw
was
Mr.
filed
Thompson's-
a week or so after cert was granted.
The
It's
blue?
my best recollection. The gray brief was filed well after cert was granted. That
Okay.
is correct.
Okay. Okay.
So, again, the question to be decided is, are you going to excuse the defendant for objecting? I mean, you are the Supreme Judicial Court. I mean, you tell the rest of us what the law is. When you tell us what the law is, that's what it is. And it would
Well,
be
I
fundamentally
suppose what makes this a little bit different, it wasn't as if in Verdi we were unaware of Crawford. When we looked at Crawford, right?
You looked at Crawford
And
and said
said-
the certificates do not
I
violate.
mean, it wasn't as if Verdi reaffirmed about certificates but didn't address what Melendez-Diaz addressed. I mean, we went one way, the United States
Correct.
Supreme Court
That's
went
correct.
the other
And
way.
And the defendant's point is that the ordinary fallible lawyer has to be able to rely upon what you say unless and until you overrule yourselves or you were overruled in Washington.
But aside from that, as the Commonwealth argues in its opposition to your supplemental memorandum, in this case, was the question of what the substance was, it doesn't seem to have been an issue. It was accepted that it was cocaine, so that what would the harm be to you? I mean, everybody acted as if this man was going to buy and was going to turn over cocaine. It wasn't as if it could possibly be baby powder or, or marijuana or anything else.
Well, the defendant responds to that by saying that that's really engaging in burden shifting. I mean, the defendant has no burden of proof on any, no matter what the...
Wait, why is it burden shifting?
Because
Explain.
all the essential elements of the crime are always live issues, because the Commonwealth must prove all the essential elements no matter what the defense is, no matter what the defense...
Well, doesn't it prove it? But when somebody testifies, he said he was going to get some cocaine for me. He said to me, here is the cocaine.
Well,
the Commonwealth could prove it by that.
In the present case, the defendant was not the seller. He was the buyer.
That's another issue. You argue.
But
yeah.
this distinguishes, what I think the court is sort of arguing is what you held in Connolly, in which part of the evidence that you used to make the certificate harmless beyond a reasonable doubt was the fact that the seller said what he was selling was cocaine. In the present case, the defendant was a buyer. In the present case, the defendant, the Commonwealth's evidence is that the defendant was using the undercover officer's money to acquire cocaine for himself and the undercover officer.
But then he gave it to the officer, and isn't that an offense?
But I guess if the question I think you're asking is, was the evidence sufficient to make the certificates harmless beyond a reasonable doubt? And what the defendant's trying to argue here is that in the present case, unlike in Connolly, the defendant was not in a position to know what it was that was being sold because he was not the seller. He's in the street haggling with defendant Green, trying to get more cocaine.
What about the
for his
first
money.
But he's
What about
trying
the
to
first
buy
piece?
cocaine.
Yeah, there's no question he was trying to buy cocaine, but if in a harmless beyond a reasonable analysis, under the Supreme Court's holding in Chapman versus California, the analysis is whether the certificates themselves had any influence on the jury's decision about whether this was cocaine. And what the defendant is arguing here is that when you have these documents, such as certificates of analysis, I mean, consider what these documents are. These are official government documents saying this substance was tested and scientifically determined to be cocaine. No matter what you have for other evidence, that's going to be the most important evidence to the jury. In the jury room, the jury's not going to have to sit there and think about, well, who said what was the evidence on this or that or the other. These are exhibits that are going to be in the jury room. The jury can look at this document, and this is going to be the piece of evidence that is going to convince the jury that this is cocaine.
But it seems to me there are two separate issues here. One, there was no challenge to the substance at trial. And you say, okay, well, that's fine, there wasn't, but the Commonwealth still has to prove its case. So
Correct.
The question is whether there was sufficient evidence. So what is the other evidence that this was cocaine? And I think that's what the questions were getting to.
In the present case, the only other evidence was that the defendant was out seeking to buy cocaine.
Well, not exactly. The defendant approached the undercover officer, asked him what he was looking for. The officer told him what he was looking for. He got in the car. He said, well, I have some here, but it's not as much as you're looking for. Let me give you the cocaine
Correct.
I have here, and then gave it to the officer.
Correct.
Then they went looking. He said, I know someone else who has more.
Mm-hmm.
They went up the block. He got out and negotiated for more cocaine, which was then delivered to the car. I mean, isn't that enough for the jury? Isn't that sufficient evidence for the jury to consider the question and find beyond a reasonable doubt?
It was certainly, if the issue being decided here was a sufficiency question, the defendant would agree. That would be sufficient. But that's not the analysis here. The analysis is harmless beyond a reasonable doubt. And according to the Supreme Court, that
harmless
means
beyond a reasonable doubt in the context of a case in which the substance, the nature of the substance, was not a live issue.
But the defendant's position
I
is that the
suppose
nature
one
of the
reason-
substance is always a live issue because the Commonwealth must
Well, I
always
suppose
prove the
they
They
evidence.
I
must prove
suppose-
it, and that's the question of the sufficiency of the evidence. But a live issue suggests something else, a contested issue at
I
trial.
suppose one reason it's not a live issue is because you've got a certificate from a state laboratory that says this is cocaine.
And how can he possibly challenge that when you have this official government document saying it's cocaine?
Well, he can. That's not an argument because he could challenge it. He could summons in the witness.
Well, he could.
If
but
you
there's
wanted
there's
to,
no
you could,
reason.
but you know it's not going to do you any good, so of
Yes,
course you don't.
But
No,
again, I
but
mean, but the defendant.
But on your theory, there is absolutely no case. I mean, even Connolly, it seems to me, if you take your argument to its extreme, there's no case in which it would be harmless beyond a reasonable
Well, the
doubt.
defendant disagrees with that because the critical distinction in Connolly is that you had field testing. I mean, there was some scientific evidence demonstrating this was cocaine, more than just somebody saying, well, based on my training and experience, this was cocaine. In Connolly, certainly field testing does not have the kind of reliability of testing by a chemist in a laboratory, but it is at least something more than someone simply saying. And again, in harmless beyond a reasonable doubt, what we're looking at here is, did this document have any influence on the jury's verdict? And the defendant's position is that given that this is such a powerful piece of evidence.
The document was admissible. The question is whether I mean, it's not as though it wasn't admissible, right?
But
I mean, you needed to be able to cross-examine.
It was admissible, but it was not admissible without the analyst being there. And if you grant that the defendant is excused from objecting, then the document was in evidence improperly. And if you remove that document, then the question becomes, was that document itself the most powerful piece of evidence that the jury had?
Accept your argument, then we would have to say in every case, unless there were something like a field test the way there was in Connolly, the certificate could not be harmless beyond a reasonable doubt. That's really what you're arguing.
I would agree, yes, Your Honor, that unless there is something more than simply somebody say, someone can, just because someone says something, that is certainly relevant. For example, suppose we had no certificate here, and the only evidence was the circumstantial evidence, then certainly all that evidence would be highly relevant in a sufficiency argument. But when you have that document, the jury's not going to pay attention to anything else because this document itself is such a powerful piece of evidence. I mean,
How long was the trial in this case? A day? How long was the trial? A day, day and a half?
I think it was a day, day and a half,
Yeah.
something like that, yes.
Well, it's not really the document. When you have it tested by a state-certified laboratory, you're in trouble, right? When it's tested by a state-certified laboratory
And it turns
comes
out to be cocaine.
you've
that
got
would
a problem, right?
Sure, but certainly, but again, under the Melendez-Diaz, that could not come into evidence without the
But you're
the evidence
faced with
being
the
there.
problem, so the question at trial is, do you challenge the test or not?
Well, you don't challenge the test if you don't have any reason to challenge the test. You don't have any reason to challenge the test because you've got a document from a laboratory that nobody's challenging. Nobody's challenging the test. It just so happens that what the United States Supreme Court has done is to throw a little cat among the pigeons.
Correct, and according to Melendez-Diaz, you can't bring this document in without an opportunity to cross-examine the analyst.
Put it this way, Mr. Hill.
Yes.
Would it be, and I'll ask Mr. Thompson the same thing, would it be possible to convict the defendant of the crimes for which she was convicted in this case had the certificate not been introduced in evidence?
That's a jury question. If what you're asking is, was there sufficient...
I understand the Chapman. It's a very, very high barrier that you have to get.
If you're asking me would it survive a required finding of not guilty, the defendant would say yes. But that's not really the question. The question is...
I understand that. But in other words, presumably, the evidence was admitted, turns out improperly, but it was, under Melendez-Diaz, because it was relevant, right? It was
Correct.
relevant because somebody had the burden to prove that it was cocaine, not
Correct.
baby powder.
Correct. But once again, there was certainly sufficient evidence to convict. The defendant's not making a sufficiency argument. I mean, there is no sufficiency argument to be made here. The question is, were these documents admitted, was it harmless beyond a reasonable doubt?
I have a question. Oh, go ahead.
I'm just wondering whether you, because I don't know how much time you have left, but you might want to turn to your other issue?
Yeah, I briefly on the joint.
I had a question on that issue. That was what I was going to address. Why do you say on page 9 of your brief, you say the result would be different if Fluellen, the defendant, and Green had been tried separately?
Because
Why
under
do you- I
prior
understand.
precedent, if you have two joint ventures or two conspirators, if they're tried separately, separate juries one jury can find the defendant not
Right,
guilty,
right.
defendant guilty. But if it's at the same trial with the same jury under your prior precedent, at least with conspiracy, if you have two people tried together and one is found not
Well,
guilty.
with conspiracy, yes, I
Right.
grant
And
you,
with-
but why with joint venture?
Yeah, conspiracy and joint venture
They're
aren't the same
different,
thing.
yeah.
Well, the defendant argues that the rules governing conspiracy and joint venture should be the same, and here's the reason. The Commonwealth's principal argument in opposition is that all you really have here are inconsistent verdicts. The defendant's position is that the reason that rules governing inconsistent verdicts do not apply here is because with inconsistent verdicts, if you ignore the inconsistent acquittal, focus only on the conviction, you have a perfectly viable freestanding conviction. With joint venture and conspiracy, if you ignore the second person, there is no crime.
But why is it? I don't see why the verdict is inconsistent here, because possibly the jury just thought that there wasn't enough evidence to convict Green, but that there was another. I mean, obviously, the defendant got the cocaine from one of those men, either that or.
Because the judge's instructions in this case were very specific. The judge's instructions limited the jury to finding a joint venture and a joint venture with defendant Green. If the instructions had been different, such as in the Williams case, where the judge did not limit the jury to finding a joint venture between the defendant and his co-defendant at trial. Therefore, in Williams, it could have been affirmed based on the defendant having a joint venture with someone else. In the present case, the judge's instructions limited the jury to finding a joint venture between the defendant and co-defendant Green.
As I recall, the judge said the Commonwealth alleges that the defendant was in a joint venture with Green.
No, that's the Commonwealth's version of the facts. What the judge said was In this case, the Commonwealth has alleged that Mr. Fluellen was in a joint venture with Mr. Green.
Correct.
And that's what the Commonwealth theory is. And I'm going to give you more about these three elements that the Commonwealth must prove in order to establish that Mr. Fluellen was in a joint venture with Mr. Green. Mr. Thompson didn't have that in his brief.
But I think it went beyond that. I believe that if you look at page 4 of the defendant's reply brief, it said, in this case, the Commonwealth has alleged that Mr. Fluellen was in a joint venture with Mr. Green. Mr. Fluellen, Mr. Green, it is their right deny that claim, but that's what the Commonwealth theory is, and I'm going to give you more about these elements. What isn't the judge really saying here is that this is what the Commonwealth is trying to prove here, and this is what you must find.
But what you need to find for proving that someone is guilty on a joint venture theory is that they participated in the crime and that they had the intent in a meaningful way and that they had the intent necessary to commit that crime. So whether they find somebody else was part of that joint venture really isn't an element as opposed to conspiracy. Isn't that right?
Because of the specific instructions the judge gave to the jury in this case, the defendant's position is that the judge actually limited the jury to a joint venture with Green, didn't give the jury the option of a joint venture with someone else. See, my time is.
Thank you.
Thank you, Mr. Hill. Mr. Thompson?
Good morning, Your Honor. Robert Thompson on behalf of the Commonwealth. Your Honor, first, Your Honor, I quoted the instructions in my brief. I left out the words at the end of the sentence with Mr. Green. I apologize to the Court. That was unintentional. If you look at the gist of my argument there, it's where I am trying to acknowledge that, in fact, he did say, the judge did say that the Commonwealth alleges that Mr. Fluellen was engaged in a joint venture with Mr. Green. My point is that simple factual statement referring to the Commonwealth, at least a part of the theory, was not reasonably viewed by anybody. It could not be reasonably viewed as a limitation on the elements. When he went on to the elements, he talked about that Mr. Fluellen had to be aiding and assisting another person. The other person. Mr. Green was not mentioned again. The elements are not restricted in any such way as to that. The Commonwealth's argument to the jury was not restricted to Mr. Green. In fact, the Commonwealth had argued, and that's at the Commonwealth had argued at page 31 and 32 of Volume 3 that, in fact, it was quite reasonable to look at all four men on the street there that Fluellen interacted with the undercover officer as essentially acting as a team. Your Honor, but I did not intend to mislead the Court and suggest that
it's got nothing to do with intentional. It was just the whole argument was it didn't say. Green, now you say that he didn't object. Why would he object to the instruction? Don't forget, the jury hasn't at this point come back and acquitted Mr. Green. So the instruction is, it's a perfectly straightforward joint venture instruction. If anything, it's slightly favorable to the defendant because it says, the Commonwealth is trying to prove that he was in a joint venture with Green, and you say he didn't object, therefore it's a substantial risk. Why would he object?
Your Honor, the point is never, there's no objection here, there's no suggestion. This whole issue in terms of consistency of the verdict was never raised at all in the trial court, Your Honor.
Well, it can't be raised until the jury acquit.
And it wasn't raised after that in any event. I mean,
But how do you mean it wasn't raised after that? I mean, he can't. There's no issue until the co-joint venturer, if there's one, is acquitted.
My point, Your Honor, is that when the judge specifically instructed on the elements of what was required in order to prove joint venture, he referred to Mr. Fluellen aiding and assisting, and other person, some other person. Those elements were not restricted in any way to Mr. Green, and there was no request for them to be.
No, I understand that, but in fact he did go on to say the Commonwealth is trying to show that it was Mr. Green, but that's not my point. My point is there couldn't be an objection until the jury, in fact until the trial is over, until the jury comes in and says Green is acquitted.
There could be an objection to the recitation of the elements that did not restrict them to Mr. Green. If he thought that they should be restricted to Mr.
No,
Green,
he didn't
could
think
do
they
that.
should be restricted.
Shouldn't he?
I don't think that's his argument. He's saying the judge did restrict it.
Your Honor, I'm asking you to read the instructions with the elements and that one
No, I understand.
simple factual statement that the Commonwealth made that allegation and suggested no reasonable juror could read that as restricting them to a consideration of Mr. Green and Mr. Green alone as a potential joint venture.
I have a question about the facts of the case. Was the case tried solely on the distribution charge being what the defendant got from the four people, any one of them or all of them, on the street, and then gave to the police officer, or was the jury also given the option of finding the defendant guilty based on what the defendant first gave to the officer
Your Honor,
and was
I
returned?
I raised that argument in my brief upon further review of the instructions and further review of the way it was presented. It was presented to the jury as if Mr. Fluellen had engaged in a joint venture. It was not presented to the jury by the instructions as if that earlier, perhaps temporary exchange could be the basis of the conviction.
So
and
the
I'm not
trial
making that
proceeded
argument
only
any
on the
further.
basis of what the defendant got from the group of people?
Yes, Your Honor.
Okay,
I believe
okay.
that's
Okay.
the way it went.
Now, help me understand why this would be a joint venture. The actual distribution was the handing of the $40 worth of cocaine by Mr. Fluellen to the undercover officer. That's the distribution, correct?
There is a distribution in picking it up off the floor and handing it to the undercover officer. There's also a joint venture in facilitating the delivery into the car of that to the undercover officer.
But at some level, every drug deal is a distribution because the person who hands the drugs to somebody got it from somebody else.
Well, you mean every drug distribution is a joint venture for the most part. Certainly,
Unless you're prosecuting a Mexican or a Colombian cartel.
or the marijuana grower. No, I understand what you're saying.
It was Green who spit it out into the car, wasn't it?
It was the undercover officer identified Green as the person who spit it out.
It wasn't the
into car.
defendant, is my point.
No, it wasn't the defendant. At
So
that
it would
point.
have to be a joint venture, right?
Well, Your Honor, the defendant then picked it up off the bottom of the car and handed it to the undercover officer.
But why does it matter from whom Fluellen got the cocaine? If Fluellen hands it to the officer, he's involved in distribution, regardless of where.
It doesn't, Your Honor. The instructions, though I will concede, the instructions did present this case to the jury as a joint venture instruction.
Were
The
those
defendant
on-
may have gotten more than he deserved, but that's the way it was presented, Your Honor.
And that was at the Commonwealth's request? Did the Commonwealth ask for the joint venture instructions?
We did ask for the joint venture instruction. I don't know that we asked for it as a exclusive presentation on joint venture.
Did it go to the jury alternatively as principal or joint venture liability?
I don't think there was a discussion. No, I don't believe it did, Your Honor.
So it only went on joint venture.
It only went on a joint venture.
I believe that's true, Your Honor. But here there was there was ample evidence that the defendant facilitated the delivery of the drugs into that car, into the undercover officer's car, to the officer. He facilitated that exchange from Mr. Green towards the undercover officer.
There was another undercover officer parked or in a car some distance away that I believe testified that Green did not lean into the car and spit the drugs
He
into the car.
testified that he didn't see anybody lean into the car, Your Honor.
And you argue in your brief that, I think, that there's an inference from that it was actually the defendant who brought the drugs into the car.
No, Your Honor, I didn't argue that. What I brought that up to suggest that there was some issue raised during the trial as to the undercover officer's identification of Mr. Green as one of those four gentlemen who delivered the drugs. Not that the defendant had the drugs somehow on him, but that there was some issue raised as to the sufficiency of the evidence of Mr. Green out of those four gentlemen. The officer admitted that at one point another one of those gentlemen had jumped into the car and asked the officer, "What do you want?" At different times, the officer had given two names on that. And then I pointed out that there was also a seeming inconsistency between a possible inconsistency or something the jury could see as an inconsistency between what the second observing officer saw and what the undercover testified to, enough to raise potentially a possible doubt about the sufficiency of Green's identity as to the one of the four people there, to distinguish and suggest a rationale for Green's acquittal and the defendant's conviction that does not have anything to do with inconsistent verdicts, Your Honor. Your Honor, the defense here sort of more broadly is asking the court to extend the rule of consistency to joint venture cases. I suggest that there's no justification for doing so. As was pointed out in the Savanti case, which was the case at 387 Mass 280, which had said that they declined to extend the rule to situations where co-conspirators were tried in separate trials. As pointed out there are very many reasons why a jury can acquit one person that have little or nothing to do with determinations of actual innocence or actual lack of sufficient proof. The courts in the Commonwealth have in the past rejected the idea that that rule of consistency should apply to joint venture, and I suggest that rationale controls. Further, it is well established.
You said we have rejected that it should apply?
Your Honor, the appeals court has rejected it, and this court has affirmed that decision without talking about that particular point. The two cases I'd cite is Commonwealth versus Clements and Commonwealth versus Robinson.
I thought you said that we had.
Your Honor, it's well established in the Commonwealth and I suggest in most jurisdictions that it is improper and inappropriate to try to go behind the verdict into the thought processes of a jury, and that we are not to speculate or inquire into their particular thought processes. What is before the court is limited to the defendant's conviction, and as I suggest, it's supported by sufficient evidence and on proper instructions concerning the joint venture that there's no reason to do anything but affirm the conviction. Further, as recognized in this court's recent case of Commonwealth versus Zanetti, joint venture is really a theory of individual liability, and the only real question is whether this defendant has participated in the crime enough with the requisite intent in order to be held liable. And this distinction between principles and joint venture are not really supported by the underlying theory. And here there was indeed sufficient evidence that this fellow, at the least, participated enough in the commission of this crime with the requisite intent to be held liable. Your Honor, on the Melendez-Diaz issue, there's not only a lack of a challenge here, there is the defense itself, through the attorney there, is asking the officers to characterize the substance in question as cocaine. They are asking the officers to agree that so-and-so then leaned into the car and spit out the 2 bags of cocaine. This is a tacit admission by the defense that this is cocaine. It takes the issue completely away from the fact finder. No reasonable fact finder would think that they have to pause long on thinking whether this is cocaine. The whole gist of the defense was to admit that this was cocaine and just claim that this fellow was really should be viewed just as a joint buyer rather than a seller
Mr.
at all.
Thompson, the jury had in front of them a certificate that said this is cocaine.
Right,
there was
Your Honor.
almost no basis on which the defendant, at least at the time of trial, could challenge that.
No, I don't agree, Your Honor. That's the jury is instructed that certificate is not controlling, not dispositive. It is always open to challenge. Your Honor, it would be a very simple thing for a attorney to challenge it. All they have to do is suggest to the authenticating officer what kind of tests were done. How dispositive
I know, but they're not going to do that if we've said that it's okay to let this in, and there's no, as far as I can see, there's no basis to challenge this certificate, this particular certificate.
Your Honor, the defendant can raise
Mr. Thompson, may I just finish? Prior to Melendez-Diaz, unless one had I assume, some kind of independent evidence that the tester was not qualified, it would be a waste of everybody's time to challenge a certificate from this laboratory that this was cocaine. You
No,
wouldn't
Your
do
Honor, I
it.
disagree. It's a very simple matter for the
Mr.
defense
Thompson, I
to
can
go through
hear-
it. Very simple questions. Ask
But
the
we've
officer.
just told them it's okay to let the certificate in.
It's a piece of paper, Your Honor, that the weight of that piece of paper could readily be challenged. And they could challenge with the witnesses right there, what do you know about the testing? Well, how dispositive is it? Is there anything that could give a false positive? And then argue to the jury, and they expect you to take this piece of paper as proof beyond a reasonable doubt. Your Honor, it's not a difficult thing to
Who
raise a
could they
challenge
a-
here. I
Excuse me,
suggest
Mr. Thompson, of whom could they ask such questions?
the authenticating officer on the stand.
There's no authenticating
He or she
officer.
wouldn't know anything about the test.
And the
so-
jury would find out that he knows
You know,
nothing about the test,
judge
and that would go to the
The judge
weight.
would rule that you can't ask it of this officer.
Why would he rule that, Your Honor? It
Because-
seems perfectly appropriate.
No, this officer has no basis for any knowledge about it. This officer
And if he
wasn't...
tried to subpoena in the examiner, the Commonwealth appropriately would have been in there saying this is a complete waste of time. There's no basis. Let him suggest that.
No, Your Honor, the Commonwealth would not be not in a position to say it's a complete waste of time, because as every jury instruction on these certificates say, is these things are not dispositive.
Thompson, if
and
that's
they're
the
subject to
basis of
challenge.
your objection to the Melendez-Diaz, I would suggest it's not the strongest basis.
Your Honor, I suggest that what's going on here is not that the defendant doesn't think that somehow the certificate is unchallengeable, but rather they have reason to believe that in fact this was cocaine. So they know that there is nothing to be gained by the challenge, because it just invites stronger evidence that makes them look worse. Your Honor, I think my time is up.
Thank you, Mr. Thompson.